to see you. May I approach, Your Honor?
Good morning, Your Honor.
I understand you all want a jury trial?
That's correct, Your Honor.
The defendant demands the jury trial today. I don't need it.
This is a suit on the debt.
Your Honor, it's a property damage claim appealed from the Justice of the Peace Court concerning a motor vehicle accident, Your Honor.
Have you done mediation?
We did, Your Honor.
I attended mediation. The defendant didn't attend the mediation, but Colin showed up.
Your Honor, we were present with our carrier with full
Was your
authority.
client present?
Client was not present, Your Honor.
The order requires the client to be present. All parties are to be present, but on the seat. If the adjuster is going to be making the decisions, they need to be there as well. But your client is the named party and the order requires that they be there.
Your Honor, I had the sign-in sheet for mediation, but I also had emails sent from Colin, the attorney, to me saying that he was going to file a motion for sanctions by saying that I did not attend mediation, and I had the sign-in sheet with my signature, Colin's signature. Another individual represented by Colin's, by the defense, neither the witness or the actual defendant appeared. And I can produce the email, the harassing email he sent, and the sign-in sheet immediately.
Your Honor, Mr. KUSNER is misrepresenting what happened at mediation. And we consider
He's
that
breaching the
to be
privacy. He's
cannot
breaching.
talk at the same time.
unable to be present in mediation, which I pointed out to the court. Mr. KUSNER was there, Your Honor, and the mediation did not go forward very long, Your Honor, before Mr. KUSNER left the mediation. That's, in a nutshell, what happened.
And like I was saying, he's breaching the privacy of the mediation negotiations. It's either successful or not successful. But again, Amar didn't show, and I had the sign sheet, and I also have the letter that he sent to me that he, can I show those to you, that he wants to.
Show it to Mr. Hatcher first.
Okay, here you go.
Your
Here you
Honor,
go.
I'm going to see-
On November the
I
14th.
said show it to him, not read it.
Thank you.
If
Here it
he
is.
wants me to look at it, you need to look at it
All
before.
right, Your Honor, it's not disputed. I sent him a letter.
May I show this to you? Thank you.
It's also not disputed, Your Honor, that no sanctions were sought against Mr. KUSNER following the mediation. So I'm not sure why we're discussing this at this time.
I also have the sign-in sheet for mediation with me.
I have that.
Okay.
It does say on here, failure to attend mediation, Mr. Hatcher.
Your Honor, the plaintiff stormed out of the mediation within 15 minutes of the mediation starting.
He's breaching the privacy of the mediation.
However, Your Honor, I did not seek those sanctions. That was I was considering doing it, Your Honor, and we elected not to do so.
Well, if he was there, he didn't fail to attend. If you think that he did not meaningfully negotiate, that's different than failing to attend. So what's going to happen is this case is going to be reset. You are all going to go to mediation. The adjuster will be there as well as your clients. Well, just your client. Mr. KUSNER, you will be there. The court expects all parties to negotiate in good faith, which means that you shall remain there until the mediator declares an impasse.
Thank you. I would like to say I did actually request, I've only filed one single document with this court, and that was about the mediation. And we had a hearing in which neither the defendant nor the attorney showed up. If you remember, that was on August the 29th, and apparently on August 28th at about 5 o'clock, Colin fell ill with 102 point something temperature. He couldn't get a backup attorney, and when I showed up, and you were here too, the bailiff had to call a halt because the court didn't know whether or not Amar was going to show up.
I'm not sure what the relevance of this is.
The relevance was I was trying to say that I don't have the money to pay for mediation. I'm trying to keep the costs down for this. The defendant
It
had,
was sent to low-cost mediation.
I know, thank you, but only because we had that hearing.
No, because you don't have an attorney, and the county has a program for people that are self-represented.
Thank you, but I thought the distinction was the defendant could have requested a mediator that they custom would want, and I would be expected to pay for that. I wanted to address to the court.
Appoints mediators where there is an individual that is not represented by counsel. We appoint someone through the court ADR system. That dispute resolution takes place up on the 6th floor.
I know I attended. Thank you for that distinction. That's why we had the hearing, and I'm glad you were able to tell me about that. We had another hearing that the defendant ordered, and if you remember, he wanted to depose me. And you had to inform him that this is a trial de novo and that your jurisdiction for discovery is limited to what the JP courts have. You then asked him in this court, did he request discovery?
How is that relevant to going to mediation again?
Because thank you for asking. I'll show you another email he sent to me.
What I'm asking is how any of that is relevant. The case is not going forward today. There will be no discovery because there was no discovery at the JP level. So rehashing what has happened in the past is not advancing the ball.
You had asked me, though, why I was bringing up that distinction, and I wanted to illuminate that for you because it seemed like you were wondering about it, and I wanted to provide an answer. Is that okay?
Well, no, because I don't think it's addressing the concern that I had.
It was the order of whether or not I was going to be deposed and whether or not I was going to be deposed before mediation or after mediation.
And I denied that because discovery was not requested at the court below. So that's not advancing anything. Right now, what I'm ordering you to do is to go to mediation, all parties to appear.
Okay.
Your Honor, on behalf of the carrier, we will offer to pay the fee for Mr. KUSNER. That will assist you in the mediator's fee.
I don't believe there is a fee upstairs.
But then we're fine.
May I bring up one thing? The last time this was set for trial, we appeared, and Amar was rushed in here, although he lives 2 counties away, and this was reset because of Amar's health. Before you discharged him to Seth Little's coordinator's office, you had said that Amar must bring his physician's note to the next hearing. I am curious if that occurred. Did he even provide the note for the reason why this trial was reset previously?
Well, I think you need to discuss that with Mr. Hatcher.
It was something that the court had
Well,
asked
free
about.
to go. In fact, you should go upstairs now. Seth, you want to welcome up there? Can you get your adjuster here? You're all here today, so you might as well go ahead and get it mediated today.
I will contact the adjuster.
If the adjuster is not available today to be here but in seat, then we'll reschedule it for a day when everyone can be present.
May I ask one
Yes, sure.
question? The court phoned me yesterday at 3:25 p.m. I was boarding a train and I couldn't take it. I asked if I could please have Seth Little's court coordinator's email.
I do need you.
Okay, I'm going.
What do you have for me?
Brought a trial up. They need to mediate. They didn't have all of their, the parties were all here for the mediation last time.
Okay.
So they just need to reset a mediation date with you.
Okay, when was the trial?
Trial said it was today, so we'll reset the trial after you
After?
get the mediation.
Okay.
set.
Okay, so then all the parties are here?
Everybody's here except for the adjuster, I believe, for the defense.
Okay, so we'll get you information and we'll set it up.
Want the case number?
Okay.
18 32 61 A.
All righty.
All right. She'll take care of y'all folks.
Thank you very much.